Our next panel is John Mayo, Howard Symons, I'm sorry, from Cable and Telecommunications Association of New York, and Lawrence Spivak. Thank you. And whomever would like to begin. I'm sorry about my voice. Go ahead.
I guess that's on. I guess I'll, by consent of our panel here, I guess I'll start if it's okay with you, Madam Chairman.
Of course.
My name is Howard Symons. I am here today representing the Cable Telecommunications Association of New York. And I'd like to just make a couple of points and then hopefully get into questions with you. First, I think it's important to acknowledge that the reason that New Yorkers have broadband, high-speed internet access is because of the investment of billions and billions of dollars by cable operators and by phone companies in the city. In New York City alone, Cablevision and Time Warner Cable have invested billions since 1995 to bring high-speed access here. It didn't just materialize. The prior panel, I think has done somewhat of a disservice to the debate by setting this up as a discussion between good and evil, and that's not really the debate. And I know you recognize that, having been involved in this issue for many, many years. It really is a very difficult debate over the role of government in a sphere of the economy, or up to now the government has not been very much involved at all without much seeming detriment to the public. And indeed, I think the consensus is that the government's light touch in this field has been one of the primary factors in bringing the benefits of open internet to the public. Our concern as an industry is that a change in that role of the government could enact the most serious law of all, and that's the law of unintended consequences. That in the desire to codify openness and internet freedom, the actual outcome may be much different. Not because necessarily providers will invest less or differently, although I think that could be the outcome, but because the role of the government here is both unnecessary and, we fear, counterproductive. Unnecessary because all of the goals embodied in your resolution and in the net neutrality principles are already the policy of cable and other internet service providers. The advancements that the prior panel spoke of, the programming, YouTube, the program that Mr. Brodsky spoke of, those are all available today because there is an open internet. To listen to the prior panel, you would think we are in dire jeopardy of facing some sort of closed system that was going to undermine innovation, and just the opposite is true. Every cable broadband subscriber today can access the content that she or he seeks over the internet. Cable operators don't block content. Cable subscribers can attach any gaming device, any computer to the internet. There's not a problem with that. Cable subscribers can run any application, access any service over the internet. There's no problem with that. The idea that we face a crisis that requires government intervention is totally contrary to the facts. And so in addition to a net neutrality regulation being unnecessary, we also fear it's counterproductive because the ambiguity and the uncertainty that regulation will inevitably introduce will slow investment, or at least deter investment, redirect investment, make it much more difficult for network operators to run their businesses, because every dispute or every judgment call will become a dispute, will become a government dispute. I'll just give one example and then I'll stop. The prior panel said, look, we understand network management is complex. Nothing will deter network management. Nothing will deter the ability of network operators to protect against spam and viruses. But in fact, there was a very real debate over how to manage the network in order to prevent those things from occurring that led to a sanction of Comcast because of a judgment they made in how to manage the network in a way that really is not content specific. Those kind of judgments in a world where net neutrality is legislated, those kind of disputes will become commonplace. And making disputes commonplace and involving the government in those kind of decisions will slow the very kind of investment and deter the very kind of dynamic advancements that I think you want and we want for our customers.
Thank you very much, and thank you for all the service to New York that you do.
Thank you, Madam Chair. My name is Larry Spivak. I'm with the Phoenix Center. It's a pleasure to be back to New York. I actually, just for the record, I'm a graduate of Cardozo School of Law up the street. I've actually even worked for the New York City government when I was in school, and I used to live right across the bridge there in Carroll Gardens, so it's really great to be back.
Glad to have you here.
Let me take a different way of skinning the cat on this. If you look at my record, I've been a very vocal proponent of the FCC having a strong authority to deal with problems and making sure that we have an open internet. My issue is not necessarily with the FCC doing it, but the process in doing it. I think the current system works because I think it's a very careful ex-ante approach where you can look at it, see if somebody did right or wrong. My issue is with moving from a careful sort of scalpel ex-ante, ex-post approach to a sort of blunt ex-ante non-discrimination rule. And let me tell you why. Because if you look at the rules that are being proposed, you look at the legislation, they essentially say you've got to build your way out of congestion. And when you do that, inevitably what that means is that these rules will end up leading to higher transaction costs, higher prices for consumers, less innovation, and more likely increased industry consolidation. Let me give you just 2 points to sort of bring this into concept. If you go back to 2000 and the auction of the 700 megahertz spectrum, you had 2 blocks of spectrum. One was encumbered, one wasn't. Verizon bought the encumbered spectrum with the openness requirements, AT&T didn't. Verizon paid about 40% less in their bid for the encumbered spectrum. Why? Because they accounted for about a 32% reduction in profitability in using that spectrum in their bid. Now that's fine, they paid less. But here's the thing, if you take a rule that will reduce industry profitability by 32% and apply it across the board, that means somebody's going to go bust. So if your rationale that we need net neutrality and non-discrimination rule because there's insufficient competition, you're actually going to make things worse. Now, secondly, as you all are probably aware, with the Recovery Act, the United States is going through this giant zeitgeist of a national broadband plan. And it's a very worthy social goal to make sure that all Americans have ubiquitous coverage at affordable rates. Fantastic. Friends of mine are working on that right now. If you have a rule that by definition will raise entry costs and lower firm profitability, then by definition you're going to get less deployment. And we've done a bunch of work, and what more importantly is you're going to end up, these smaller firms out in rural America, or even smaller firms in urban areas, are going to bear that brunt much more disproportionately if they have to build their way out of congestion. So what does that mean? It's going to mean that the subsidy is going to go up. The FCC's broadband team just calculated that to build one network for that would be 100 megabits would cost approximately $350 billion. There's probably more to it than that. So you're talking about a huge subsidy. But you know who's going to end up paying that subsidy? Not the people out in the farms, but people in urban areas. So prices by definition are going to go up. So my point here is that we have to be very careful with the cost benefit of what we're doing. My only suggestion here is that we let the process work, let my friends at the FCC go through this process and not add to the hyperbole, but focus on what is an exceedingly complex issue. Thank you.
Thank you very much.
Good morning. My name is John Mayo. I am a professor of economics, business, and public policy at Georgetown University's McDonough School of Business, and I'm also the executive director of the Georgetown Center for Business and Public Policy. I have been studying telecommunications, regulation, and antitrust issues for 25 years. I've served as an advisor on economic matters to state and federal regulatory agencies, the Department of Justice, Antitrust Division, and various private companies. Today, it's just a pleasure to be here testifying on an issue that is of key policy interest. Let me get to the point. I will urge you to pause and indeed to not pass this resolution. And I do so for 4 reasons. First, economic research indicates that net neutrality regulation may create, in fact, more harm than good. As an example of that, we have done some research at the Georgetown Center for Business and Public Policy that looks at the issue of the digital divide. This is an issue that's been raised by many people, very concerned that the penetration rate and the deployment and adoption by lower income citizens and minorities is lower than for other Americans. We find that net neutrality regulation will actually raise prices and harm the penetration and adoption of broadband services by the very citizens that we'd like most to help. So that is, I think, a problem. Number two, I think net neutrality regulation focuses on successful markets rather than on failing markets. This is a market, the internet, that by all accounts, I think, both in the first panel and today and the second panel, has been wildly successful. A decade ago, we had 3 million broadband subscribers in America. Today, we have 65 million broadband subscribers. Affordability and accessibility of broadband is greater than it's ever been today, and firms are spending tens of billions of dollars every year deploying more broadband than they ever have before. Now, the proponents of net neutrality regulation will tell you that the solution to this is to impose pricing regulation. But I will tell you that economists are virtually unanimous in seeing government regulation or pricing as a last resort in failing markets rather than a first resort in successful markets. Third, codification of the net neutrality regulation principles would be, I think, effectively unnecessary. We have at least three federal agencies right now already focused on this issue. Number one, the Federal Communications Commission. Number two, the Federal Trade Commission. And number three, the FCC, all focused on these issues with authority under the existing laws today. Finally, I think the resolution is effectively backward-looking. The real threat, by all accounts, the real threat of the internet is to keep up with the exploding demand that has accompanied the transition from text-based messaging to video-based messaging. There's going to be a tremendous demand for the internet, and supply has to keep up with that. There's a very real and serious concern that this measure would reduce the investment propensities of incumbent companies. With that, let me stop, and I'll look forward to your questions.
Thank you all very much. One of my questions for Mr. Mayo was, I know you mentioned that the digital divide would be enhanced, so to speak, if we have this kind of net neutrality. So my question is, are you just stating that because you think the investment would decrease, or what's your reasoning for the digital divide to be, in a sense, enhanced, which is what we don't want?
Very, very good question. And in fact, separate from my testimony, I provided the exact study to you, and I'll commend it in professorial fashion to you to read it.
Thank you.
The gist of the answer to your question, though, is something that makes a great deal of common sense, and that is that minorities and low-income citizens are the most price-sensitive of all consumers. If we are going to invest, the numbers are very big, and there's some disagreement about how much, but let's call it $100 billion to $300 billion to keep up with that investment. Someone's going to pay for that, and if we allow for pricing flexibility as opposed to a one-size-fits-all pricing approach, then it turns out that we will allow for greater accessibility by those low-income, price-sensitive consumers. And again, I'll suggest that you read the study. I'm happy to answer follow-up questions from you.
Thank you very much. My other question is, this issue of competition is always hard to get your hands around, because as I think the previous panel stated, there used to be, or you did maybe, there used to be 3 million subscribers, and there used to be, 5,000 service providers, and now we have a lot fewer. And I think that I was just wondering, how do you look, and then there are not a lot of cable companies. I like Time Warner and Cablevision. I certainly think they provide great service, but there isn't a lot of competition. I don't even know if Fios is competition. So how do you think that the issue of the incumbents, so to speak, I don't think that there's much competition there, so maybe there does need to be competition for the consumer using the net. And I'm just wondering how you would answer that question, because you do want more competition. I think that's what America's all about.
Sure. In the spirit of not, since you raised a monopoly question, I'll not monopolize the panel. I'll be very brief and let my colleagues also speak to that.
I think you came the furthest, though, maybe. So you
but thank you. Again, great question. The real notion of competition, and I've been studying this again as an economist for 25 years, the real notion of competition is not necessarily given by the structure of the market. That's a beginning place. That's a nice place to start, but it's not the end. The real end of looking at competition is in prices, output, and innovation. And on those scores, this has been a wildly successful market. Should we stop being vigilant? Absolutely not. But I think by all accounts, this is a market that has worked swimmingly well to this point. Consumers have benefited tremendously. And the fact of the matter is, even though there are a relatively small number of players, they are pounding each other brutally to get your business and to keep it.
Somebody else want to answer?
Just to echo that, I mean, I think, this is not sort of the wheat business. This is a business with huge fixed and sunk costs. So the number of firms is necessarily going to be few, and that's, one of those hallmarks of our work has just been sort of recognizing realistic expectations of industry structure. I think the policies that have to be put in have to make sure, to me, I always tee it up as the policy, and this is the difficult point, is how do you get firms to compete against each other and to invest rather than to engage in some sort of anti-competitive conduct or joint conduct like colluding, or worse yet, exiting the market. And I think that's where, if we're kind of near equilibrium for a lot of these firms, for a lot of these markets, probably 2 for wireline is pretty much what you're going to get. 4 for wireless is pretty much what you're going to get. We have to be very careful. If we start making tariffing, you could be promoting collusion. That's why the FCC got rid of it 15 years ago. Again, this is a very, very difficult thing, but this is not a traditional market. So the fact that few firms may be, in fact, evidence of intense competition, as John was saying.
Yeah, I would just underscore 2 points. One is, if you look at the behavior of the market participants, they behave very much as you would want them to behave in a competitive market. Increased investment, increased speeds, increases in speeds without increases in price, everything you'd want to see. You just will go around the city and you can see the competition between the cable companies and FiOS. Behind them, you see the wireless providers investing in 3rd and 4th generation wireless. So while there may not be 5,000 players as there were back in the 90s, there are 2, and if you count wireless, 2.5, 3 providers acting very much like they're under the spur of competition in what they are investing in the city and what they're delivering to subscribers.
The other issue, of course, is do you think that a Google or a MySpace or any other innovative that's doing extremely well now would be able to be a startup today and move into the future? There would not have to be any, they wouldn't have any challenges or impediments under the current situation, what you're talking about now. And do you think that any regulations would be needed to be able to be sure that such a company could grow in the future? It could be we don't have garages in New York City, but it could be in an apartment.
Porches.
We have porches.
Porches, right. On the porch. On the stoop.
On the stoop. I like the stoop.
Right. I don't think there's any evidence of any impediment. I mean, we talk about Google and Yahoo, and they got started. But if you look in more recent history, you see the same thing over and over again, whether it's Twitter or Facebook or other similar innovators. They've gotten into business. They've grown exponentially. Facebook grew a lot faster than the prior generation of online services. I really think it's the other side of the coin on the competitive behavior of the market participants. There's no evidence, despite the sort of doom and gloom from the first panel, there's no evidence that there are impediments to innovators coming in, and I don't think that there's any evidence that the service providers, the network operators, would impose those impediments because they want to drive penetration, they want people to use their service, they want people to buy the faster speeds. You look at the increase in video use on the internet, it's driven exponentially. There's just no evidence that there's anything other than a very healthy ecosystem out here where providers want innovators and innovators are able to get to the consumers over the networks.
I just simply would add that out of this dizzying array of what has happened over the last decade, I think there are 2 points on this that you can take away and take to the bank. Number one, the internet has facilitated the emergence of entrepreneurial organizations. That's just a fact. Number two, the incentives on the part of the infrastructure providers is very much aligned with that growth of those entrepreneurial enterprises, because those are the companies that will use their networks. So in this particular instance, the interest of the entrepreneurs and the infrastructure providers are very much aligned.
I mean, given that, that's why I wonder, do we need to, then why would there be a problem in kind of codifying what the current situation is, which is what I think we're trying to say?
Well, I think there's a big difference that occurs when you take policy and responsible government oversight and turn it into a binding rule. And what happens is the binding rule becomes something that gets litigated, something that gets leveraged in business negotiations. If you don't do what I want, I'm going to go to the government. I'm going to invoke the FCC. I'm going to invoke the Public Service Commission. And that tends to distort the negotiations and I think deter exactly what you would like to see continue here in New York and even accelerate. In the 90s, the FCC under President Clinton came up with this phrase of vigilant restraint. And that worked. It wasn't that the government turned its back on these very important issues and the deployment of broadband. It was the government basically put everybody on notice that they were going to be watching. And I think that light touch struck the right balance between, totally walking away from it by the government, which I don't think would be responsible for the government, and taking rules and making them into binding statutes. Binding statutes, you write binding statutes. Binding statutes, once they're enacted, take on a life of their own and really change the character. And I guess I would put to you the question of whether it's necessary, given the facts on the ground in New York and elsewhere, whether it's necessary to ratchet up the guidelines and the vigilant restraint that's worked ratchet those up and to take on that additional character and weight that binding statutes always have.
And just to echo that point, both what Howard and John said, there is existing law on the books and it is being enforced. Respectfully speaking, the proposals on the table go far beyond what Title II is.
Okay.
Far beyond. They prevent you from pricing things out, which Title II, it's not discrimination. The case law, 60 years, 70 years, is undue discrimination, which usually means treating people in a similar class of services, of like services, similarly situated customers for like services. That's not what these rules do. These rules prevent you from pricing things out. They force you to invest your way out of congestion, which will impose huge costs. They will set new standards that have heretofore never done. The Markey issue bill actually tells the FCC how to granularly regulate the network. The FCC has never done that. Part 68, which was standard technical interfaces, this is Part 68 on steroids. So this is far beyond what we have ever done. And that's the point, and speaking as a lawyer, once there is a rule, then people start debating what the rule is and what is this, what is that, and it gets into be a mess. And that's why these ex-ante rules are so problematic rather than trying to take a more measured approach. If it was me, I would set up some sort of rocket docket at the FCC with some sort of rebuttable presumption where then the burdens of proof shift, much like the FCC did for program access. That's a much more constructive, case-by-case specific approach than sort of this blunt non-discrimination inventing all new series of law. And that's my fundamental problem with this.
how do you answer then people who, I understand what you're saying, because the term that, vigilant constraint, or the notion that you don't want to use a blunt instrument, et cetera. But how would you, one of those aspects might work for those who are concerned that the future might hold something different than the open policy that exists now. That's what people are worried about. And I think you know that. In other words, everything's okay now, but we're not going to be around forever. Different group of people might be around. And that's, how do you answer that question? Well, you know, because you've heard the arguments a million times.
Sure. I understand that concern. I think that things are okay now in part because of the structure of this vigilant restraint and ongoing oversight that we have, and that is not going away. The New York City Council, the Federal Communications Commission, is not going away, and I think all of the companies, certainly in the Cable Association and probably all the broadband providers, I can't speak for them all, are well aware that the government is constantly, this is a big issue, this is an important issue, and whether it's the City Council or the FCC or Congress or the other participants in the ecosystem, they're going to be there, and we know
they're
that.
much more important than we are.
Well, I think it's useful to have this examined at all levels of government, but I think the notion that things could change and then what, I think presumes that in fact you and others, other levels of government are going away, which is not the case. I've been dealing in this stuff for 30 years, long before there was an internet, and 10 years ago, it was the same question. What if things change? It'll be bad. And in fact, what's happened since 1998 is the explosion in broadband, the growth that we've talked about here, the openness, the lack of evidence of anything other than openness, and this notion that you have to legislate because things could change, I think presents really kind of a false endpoint. You're going to be here, and that vigilant oversight is going to continue. I don't think things are going to change in a regard that requires you to legislate.
Okay. There have been, not to bring up, but there have been some instances in the past, not with your companies, but, with some companies, and it was always feared that could happen in the future, where there was content limitation. And so that puts a fear into people. And you know that, so.
Right, I know that, and I think I know what you're talking about. I was here a couple of years ago testifying in front of Assemblyman Brodsky just after that incident.
That must have been fun.
It was a lot of fun, but not on behalf of that entity.
I know,
so it wasn't that
just
bad. It wasn't that bad for me. This is more fun. And again, I think there are going to be incidents. There are always going to be incidents that arise. There are always going to be hard cases or bad cases. But in fact, each one that's come up, whether it was the NARAL incident or whether it was Madison River Telephone Company or even whether it was Comcast, the questions over Comcast management of P2Ps, those come up, they get addressed, we move on. And I think to say that those isolated incidents are the rule that requires legislation, I think misstates their importance. They are important because what they show is that when something comes up, the system deals with it without having to have this infrastructure of legislation in place.
All right. Does anybody want to add anything else? Otherwise, I want to say thank you very much for this panel. All of your testimony will be part of the record, and I really appreciate your making the effort to be here today, and I'm glad you're in New York City. Those of you who traveled here.
Thank you.
Thank you so much.